The world of tax sales and surplus funds has been shifting and evolving for years, but few understand just how these changes have transformed the way owners, lenders, and finders navigate the claims process. Today, we take you on a journey through time, from the laws that governed surplus funds over a decade ago to the upcoming changes in Alabama that are set to revolutionize the game in October 2024. Before the amendments in 2013, the rules surrounding tax sale surplus funds were different. The law allowed the owner of the property at the time of the tax sale to claim the surplus funds without redeeming the property. It was a more open-ended system, where the owner didn't have to negotiate a redemption or prove ownership post-sale. Ownership of the funds was simply determined based on who was assessed the taxes at the time of the sale. There was no strict requirement to redeem the property before claiming the surplus funds. But then, in 2013, things started to change. The law evolved. The new law required redemption, but the redemption process became more nuanced. Owners, mortgages, and other interested parties were now working within a timeline. If they could navigate the legal maze and prove redemption, the surplus funds were theirs. Yet, the complexities still left many unsure how to claim what they might have been entitled to. The law changed to be in favor of the banks because people who did not have the means to redeem the property automatically forfeited the funds. Now, we stand on the brink of yet another shift. October 1, 2024, a new law comes into effect. And this time, everything changes. No longer will redemption be the sole key to unlocking the surplus funds. Under this new law, if an owner chooses to relinquish their right to redeem the property, if they file that release with the judge of probate, they can claim the surplus without ever having to redeem the property itself. This brings us to the pivotal case of First United Security Bank and Paty Holdings, LLC. In 2010, Wayne Allen Russell's property was sold at a tax sale. The bank held a mortgage on that property and the property went through the tax sale certificate process. The bank acted swiftly and also foreclosed on the property after the fact. By foreclosing on the property in 2010, First United merged legal and equitable title, positioning itself to claim the surplus funds over Russell. This timeline reveals a complex and strategic series of events that unfolded over the course of several months in 2010. But the court took until September 26, 2014 to decide the fate of this case. May 25, 2010. The saga begins when Wayne Allen Russell's property is sold at a tax sale due to unpaid taxes from the year prior. The buyer at this tax sale doesn't purchase the property outright, but rather, secures a tax certificate. This certificate gives the purchaser the right to eventually claim the property if Russell fails to redeem it, meaning, if he doesn't pay the back taxes, interest, and penalties within a specified period. At this point, Russell had a choice: claim the surplus funds, forfeit the funds, or redeem the property. However, Russell did not put in his claim right away. July 8, 2010, just a little over a month after the tax sale, First United Security Bank takes decisive action. Although the tax purchaser holds a claim through the certificate, the bank still holds the mortgage on Russell's property. It's important to note that the bank, like the homeowner, receives notifications of tax foreclosures. All interested parties are alerted. Recognizing the stakes after the tax sale certificate was issued, the bank swiftly initiates foreclosure proceedings on the property. By doing so, they effectively merge legal and equitable title, combining both the rights of the lender and the ownership rights. It's important to visualize what's happening here. Russell was in possession of the property until the bank completes the foreclosure process. This is where your role as finders becomes pivotal. Acting swiftly and with precision in this industry can mean the difference between securing a claim or missing out entirely. This foreclosure allowed the bank to solidify its position. By taking control of the property, First United asserted itself as the true owner, strategically positioning itself to claim the surplus funds from the tax sale, a claim that Wayne Allen Russell had attempted to pursue, but only after the bank had already moved in. The legal battle begins. Initially, in May 2012, the trial court rules against First United Security Bank. The court decides that Russell, as the property owner at the time of the tax sale, was entitled to the surplus funds. The ruling was based on the understanding that First Union National Bank of Florida v. Lee County Commission, 2011, had established that the term owner referred to the person whose name was listed on the tax assessment at the time of the sale, in this case, Wayne Allen Russell. But the bank wasn't done fighting. They appealed the ruling, bringing the case before the Alabama Court of Civil Appeals. In November 2012, the Court of Civil Appeals upheld the trial court's decision, maintaining that Russell, as the property owner listed during the tax sale, had the right to the excess proceeds. According to this ruling, the timing of the foreclosure didn't matter. What mattered was who held title during the tax sale, and that was Russell. But this wasn't the final word. The case escalated to the Alabama Supreme Court, where First United Security Bank presented its case once again. In September 2014, the Alabama Supreme Court issued its final decision. In a dramatic reversal, the court ruled in favor of First United Security Bank. The justices clarified that, while Russell's reference to First Union National Bank versus Lee County was relevant, it didn't fully apply here. The focus wasn't solely on the statute, but rather on who held the legal right to claim the funds at the time the claim was made. The key difference was that the bank had foreclosed after the tax sale but before any claim for the surplus funds was filed, ultimately granting the bank the superior right to those funds. The Supreme Court held that because First United Security Bank had foreclosed on the property and merged both legal and equitable title, it had a superior claim to the surplus funds. The foreclosure had stripped Russell of his ownership rights, leaving the bank in the strongest position to claim the excess proceeds. By the time the claim for surplus funds was filed, Russell no longer had an ownership interest, and therefore no entitlement to those funds. What we've learned from this case is that timing and swift action is 100% vital to the professional finder industry. Initially, Russell was considered the rightful claimant, but First United's foreclosure after the tax sale changed everything. By merging the titles through foreclosure, the bank asserted its position as the new owner, securing their right to those funds. This case also highlights how Alabama's laws, including the changes made in 2013, and the upcoming amendment in 2024, can have significant implications on who is entitled to surplus funds. Now, with the new law, an owner can relinquish their right of redemption, allowing them to claim surplus funds without redeeming the property, adding yet another layer of complexity. Except this time, it isn't in the bank's favor. Originally, the law was very one-sided, by forcing owners to redeem their property in order to collect the surplus. The old law allowed the bank to have the upper hand that they can redeem the property to foreclose on the mortgage, leaving the homeowners stranded. They didn't only change the law to allow the owner to forfeit the right of redemption, they backdated it to the same year the injustice took place. Claims for the funds can go back up to 10 years, with a few of the properties that were sold a few years even further back have a chance to claim. But they once again must file their claim before the time expires in order to be paid according to the new statute. The probate court has the funds, and if they don't have the funds, a simple inquiry about them will lead you to the answer, because all of this is public record with a few exceptions. So, what can we take away from this as professional finders? It's simple. Being well informed and acting decisively on behalf of the property owner can make all the difference. Understanding the timing and the laws that surround tax sales, foreclosures, and surplus funds is essential in ensuring that your clients get what they're entitled to. Pay close attention to the fact that over the past 10+ years, owners who very well knew that they needed to redeem the property in order to collect the surplus now receive your phone call, and you must explain to them that the law changes, and point the law out to them. There will be so many potential claims it's unreal, and you want to be one of the first to give them the good news. As you continue to grow and learn in this business, remember, you are setting yourself apart. By mastering the complexities of tax sales and mortgage foreclosures, you are becoming a professional, well equipped to navigate this intricate landscape. Don't forget to join facebook.com/groups/excess proceeds to get real answers from people who care. Thank you for being a part of our journey, and we can't wait to show you the exciting data we're building to help you thrive in this industry.